We've got a lot of people. We've got a lot of people on now, and we have a huge amount to rattle through this morning. So for those of you who don't know me, I'm Helen Lucas. I am a partner here at Ignition and head of our property team. I am joined this morning by my fantastic colleagues, Helen Gerrard, who is my fellow partner and head of our corporate and finance teams, and the excellent Fiona Morris, who's one of our senior finance lawyers. We just move on there. You will see we are being extremely ambitious with what we're hoping to cover this morning in the space of probably about 45 minutes of conversation. We're also extremely conscious that we have a wide audience this morning. So we've got real estate professionals on, and we've got people with little or no real estate experience or experience with finance matters. So we are going to have to be deliberately high level in what we're talking about. But as always, if you've got questions as we go along, pop them in the chat. We'll pick up as many as we can whilst we chat through our slides. And we'll also leave time at the end for anything extra. So don't worry about that. We've also put all our contact details on the slide. Oh, sorry. We've also put all our contact details on the slide. So if anyone has any some more specific questions that you think might not be of interest to everybody, then by all means contact any of us after the event and we'll be happy to pick those up. And also just a note, Fiona's asked me to highlight, we will be talking very much more about commercial property lending and development investment funding this morning, rather than taking security on a borrower's sort of family or individual home, just because that's a regulated activity normally where you'd need specialist financial advice. So we're not going to be covering that, although a lot of the points around property DD, etc., will be very similar. So Fee, do you want to kick off with the real estate finance points?
Thanks, Helen. So just to start off with, so the first point we wanted to introduce is that commonly real estate finance facilities are split into two types, so an investment facility or a development facility. Broadly, an investment facility is a loan made to a borrower which is secured on commercial property. The loan's purpose may be to acquire a property or portfolio of properties, to release funds for a borrower to invest in its business, or to refinance an existing facility already held by a borrower. Generally, with an investment facility, the underlying property will be income generating. For example, it will be tenanted, and so there'll be rental income. That income will be used by the borrower to service and or amortize the facility. A development facility, on the other hand, is a loan made to the borrower for the purposes of funding the building, redevelopment, refurbishment of a property. The loan could also include a sort of acquisition facility if the development land also needs to be purchased. And then the remainder of the loan would be used to actually fund the development costs. Once the development property is completed, either that property would be sold and the debt repaid through the proceeds, or if it's to be used as an income generating asset, the development facility would normally flip into an investment facility with rental income being applied in repayment of the loan and in service of the debt. Sometimes we see bridging facilities used in the real estate space. These are short-term funding solutions which can be put in place relatively quickly. They're there to meet an immediate funding need. So, for example, a developer has developed one property that's completed, they put it on the market, it hasn't sold, but they've identified another opportunity. They need some funds in order to pursue that. So they would then enter into a short-term bridge facility where their previous property is sold. They can then use that to repay that facility. So useful in terms of fairly quick access to funds, although it's worth noting that the pricing on these facilities tends to be higher than a longer-term financing solution. And finally, we just wanted to make a quick note on mezzanine or subordinated loans within these types of structures. So as with your residential mortgage, a lender is unlikely to lend 100% of the funds needed to buy and or develop a property. So the borrower is going to need to fund the balance some way. Now, that may be done through equity investments, through shareholders, or else it could be funded by way of a subordinated loan facility. Now, these loans could be provided by a parent company, directly by shareholders, or sometimes on larger scale projects, you see specialist mezzanine third-party funders. The rights of the subordinated lender to receive sort of repayment of their debt, interest payments, and their rights to take enforcement action would be subordinated to those of the rights of a senior lender through the use of intercreditor arrangements, and we'll provide a little bit more detail on those later. One point to note again, where a third party is providing a mezzanine finance facility, quite often the pricing would be higher than you'd see on the senior debt, and that is reflecting what the lender perceives to be the higher return to risk ratio in terms of making these loans. So a quick note on the structure of development finance and investment finance facilities. So up on the screen, you have a sort of structure chart of a kind of quite typical development finance facility. The number of parties will often be determined by the complexity of the project and the value of the project. But very briefly, if we look, so you've got the borrower developer sitting in the middle, and they will hold that development property. If you split this down into sections, so the top right hand of the screen, you'll see your various finance parties. So we've got shareholders who will be providing equity, subordinated debt, the senior lender who will be providing the majority of the debt finance, and then you would have your subordinated creditors providing the subordinated debt. Looking at the left-hand side of the screen, you've then got what we would call the kind of development parties and professional appointments. Now, the lender is going to want to be satisfied with who's being appointed to actually build the project. They want to know that they can deliver. And then at the bottom, we've got what I would consider to be the sort of income generating parties. So where the development property is to be sold, you'll have sales and pre-sale agreements for any purchases sort of off plan. And so you have your purchasers, or if the property will be tenanted, you would then have agreements, or in advance of practical completion, agreements for lease. Looking at an investment finance facility, slightly more simple structure. So the borrower may or may not already own the property. If they don't own the property and the loans to be applied in purchase of that, you'll have the seller who will receive the purchase price. You'll have the lender who's going to be making the loan and will receive security in relation to that. You'll then have, again, your sort of income generating parties, so the tenants. And on a larger scale, property, you may well have a managing agent appointed who would enter into a duty of care agreement with the lender. And I think Helen's going to come on to talk about that in a little bit more detail later. So with any real estate finance transaction, there'll be a raft of finance documents to enter into. So you will have the facility agreement, you may have your subordinated facility agreements, and also your underlying security documents, guarantees, and any intercreditor arrangements. We thought it would be useful to just have a sort of quick run through some of the kind of key terms that you'll see in one of these facilities. So first of all, drawdown. So how as a borrower and when are you actually going to get your money? With a development facility, the lender wouldn't normally provide all the money up front. You may find you have a day one drawdown, which would maybe fund the acquisition. And you would then have drawdowns against specific milestones and completed works or the submission of invoices. And there'll often be a conditions precedent exercise to go through in relation to each drawdown. Where you have an investment facility, these are often drawn in full at the sort of on day one of the facility. So very importantly, from a borrower and lender perspective, what's the pricing going to be in relation to this debt? So what's the interest rate and what fees are going to be paid? In terms of interest, so interest can be calculated on what we call a fixed rate basis. That would be a flat, for example, 5% per annum, or a floating rate basis where a benchmark rate would be taken, for example, the Bank of England base rate, and a margin applied on top of that. So the interest you're paying would potentially fluctuate throughout the term of the loan. Equally, we do see some facilities where you will have a proportion of the term being on a fixed rate, and it will then swing to a floating rate later on in the term of the facility. In terms of when interest is to be paid, under a development facility, often if the borrower has any cash flow, it is being pumped into actually the development costs themselves. And so it's difficult for them to support periodic interest payments during the development phase. Often you would therefore see interest being capitalised periodically, meaning that it's actually added to the principal amount of the loan. So you do have sort of interest accruing on interest, and that would continue until the property becomes income generating. With an investment facility, as you've got an underlying income generating asset, interest is usually paid periodically throughout the term on fixed interest payment dates. Now, one point to consider with that is normally you'd want to set those dates sort of a few days after the date on which rents are paid in respect to the property. Just gives the borrower the time to, or the managing agent time to chase up any late payments to ensure that you've got sufficient funds to make those interest payments on the required dates. Then the borrower will also be required to pay fees. So there may be arrangement fees, that's the cost of actually putting the loan in place. Commitment fees, so for example, on a development facility, as I've said, there are staged drawdowns, meaning the full amount isn't drawn on day one, but the lender will have committed to make a specified amount available to the borrower. That amount is essentially allocated to them, so they can't lend those funds elsewhere. However, while they're waiting for the drawdowns to take place, there's no interest being charged. So in order to compensate them, the lender would charge a commitment fee. There'll also be professional and legal costs. Now, the borrower would usually pick up the costs of both its own costs and the lender's costs. On larger deals, you may have a lender's agent, and you may also have a security agent appointed. Again, the financial institutions taking that role would charge a sort of administration fee for those that would be met by the borrower. And if the borrower wants to prepay the loan early and or cancel a proportion of it, then prepayment and or cancellation fees may also apply. So moving on to repayment, with a development facility, often you'll see that repayment will be stated to be due in full within a specified time of practical completion of the development. In addition, the facility will include mandatory prepayment events relating to the sales of units and properties within the development, so that the net proceeds, i.e. proceeds after the cost of sort of reasonable expenses of sale, are applied in prepayment of the facility. In an investment facility, you would either see repayment in full at the end of the term or on scheduled payment dates throughout the term of the facility. The agreement will then include a section that we refer to as representations, which essentially are a statement of fact made by the borrower in relation to all sorts of matters, but its business, its incorporation, its authorization. In addition, where you have real estate finance facilities, so on a development facility, there'll be development-specific representations. For example, these would include that the development documents haven't been breached or terminated, that necessary insurances are in place, and that in the construction there's been no breach of environmental laws. And on the investment side, you would see representations relating to the borrower's ownership of the property. I mean, you'd also see these on the development side as well, because that is key to the lender's security. So, for example, that the borrower has good and marketable title and it's holding the property free from security interest other than those that have been granted to the lender. The facility will also contain a raft of covenants being an undertaking by the borrower to do or not to do something. You would include all of the standard documents that you expect on a normal corporate lend, but in addition, there would be development-specific covenants, which essentially ensure that the development is going to be completed on time and on budget, and that the lender can monitor this. So there will be extensive reporting requirements, and there'll be requirements to comply with development consents. There may be sales and leasing targets, requirements for the borrower to fund any cost overruns, and that the works aren't varied without the lender's consent. So essentially the lender making sure that what they've been told is being built, and it's being built on time. In an investment facility, you'll see undertakings regarding the borrower's use and maintenance of the property, again, to ensure that the underlying asset, that its value isn't eroded due to poor management or lack of maintenance. One thing to ensure is that the underlying security documents, which will normally be taken over the real estate asset, will also include extensive covenants in terms of the use of that asset. You want to make sure that there's consistency across the suite of finance documents. There's no point in agreeing a sort of load of carve-outs to one set of covenants if you then have a more stringent set of covenants in your security documents. And a final word on accounts. Often the facility agreement will specify certain accounts that need to be opened by the borrower. For example, in the development scenario, there'll be a development account. The borrower will often have signing rights in relation to this, so that they can use monies in that account to pay the various invoices, etc. On some facilities, you will see that the lender will actually pay contractors directly. There would also be a sort of proceeds or a rent account. Now, this is normally a blocked account, so this would include sales proceeds or any rental income, but there would be agreed release mechanics where the borrower could withdraw money from that account if, for example, certain payments or milestones have been reached. There'll be a deposit account that will be blocked. That will be for any pre-sales proceeds, and potentially a cost overrun account. So in the event that the development is running over budget, the borrower will be required to put monies into an account. Those are then held in a blocked account and will then be released as and when those cost overruns need to be paid. Similarly, an investment facility may include provisions regarding a rent account, which again will be blocked, but normally would include a release mechanism so that in the event the borrower has met its debt service requirements, any excess or a certain amount of excess in that account could be withdrawn and used by the borrower. It's also very likely that a real estate facility will include certain financial covenants. Now, often we're asked, how much do you think I can borrow against the property? It's quite a difficult question to answer because each lender will have its own sort of credit process that it will go through. Essentially, how much it's willing to lend is going to depend on its kind of risk appetite and its risk perception in relation to the project. So does it believe in the development? Does it think it's going to be profitable? How easy does it think it's going to be to let the property? Also, it will have an overall view on what it wants its exposure to the real estate market to be, and that can all dictate the sort of amount that you can borrow under a property. But that is generally documented by way of what's called the loan to value. So that would be a covenant that essentially says that the loan cannot exceed a percentage of the current market value of the property. The facility may include cures so that in the event that when the covenant is tested, it's shown that that has been breached, the borrower is given a short period in which to prepay the facility to bring it back within covenant. But that's subject to negotiation between the parties. A similar covenant seen on development facilities would be the loan to gross development value covenant. This essentially says that the loan shouldn't exceed a percentage of the projected value of the completed development. It means it's very important to get an accurate gross development valuation and for all parties to be comfortable with the underlying factors on which the valuation has been based. So, for example, the comparables that have been taken, the perception of market conditions and market risk, looking at the location of the property, for example, will all feed into the projected valuation. Another one for the development phase of a development facility would be loan to cost. And this is essentially saying that the amount of the loan shouldn't exceed a percentage of the costs of the development. So one point to consider in relation to this is in relation to cost overruns, because this will obviously impact the calculation of that covenant. If the borrower is funding those cost overruns itself, then you need to make sure that that will be taken into account when the covenant is actually calculated. So moving on to covenants that you see more in an investment facility or once the underlying asset has become income generating. So these are interest cover and debt service cover covenants. So essentially what these are looking at is it's saying, is the net rental income being received sufficient for the borrower to meet its obligations to pay interest and fees, and also with debt service cover, repayments of principal. So these covenants are normally tested, often you'll see them tested quarterly, but that is a subject matter for negotiation. And they could be tested on what we call a look-back basis. So what was the actual net rental income that's been received? Or they could be tested on a look-forward basis, looking at the projected net rental income for a particular period. Now, one thing to be aware where they're calculated on a look-forward basis, these will be calculated on the basis of certain assumptions. And normally this is done on a worst-case scenario. Again, this is up for negotiation, but normally it would be that, break clauses are going to be exercised at the earliest opportunity, rent arrears won't be made good, that vacant parts of the property aren't going to be immediately re-let. Now, there may be cure rights for all of these covenants, as I've said, within the facility, that the borrower is given a short period if these are breached, for them to actually, where possible, to be able to cure any of the breaches to avoid the facility going into default. And so that takes us on to the next section of the facility that I wanted to briefly cover, which is events of default. These are a set of circumstances or events which, if triggered, would ultimately give the lender the right to call for repayment of the facility. It may also give the lender the right to put the facility on demand and or to enforce its security. Now, practically, if there is an event of default, it's very rare that a lender would immediately call for repayment and or seek to take enforcement action. Normally, it's a trigger for them to sit down with a borrower and say, okay, what's the situation here? What's going on? Have we got a long-term issue? Have we got a short-term issue? Is the asset just taking a little longer to generate income? So do we need to do a covenant reset? They're not going to, normally they wouldn't go straight into enforcement action. So the events of default will cover a whole raft of situations. So, for example, from non-payment of amounts due under facility, breach of covenants, breach of representations. And on property financings, there will also be a raft of specific kind of property and construction covenants. So, for example, the property isn't being compulsory purchased, there's not been any major damage. You might see if there's a particularly key tenant that they haven't terminated their lease. In a development finance situation, that the material contractor hasn't gone insolvent. And then finally, a quick note on conditions precedent. As I mentioned earlier, these are evidence and documents that need to be delivered to the lender prior to the lender allowing the loan to be drawn. Essentially, they help to inform the lender's due diligence process and to ensure that the underlying asset is what the borrower has claimed, and that the development the development schedules, budgets, etc., are all actually sensible and the project is deliverable. So it can be a relatively extensive exercise. And I know that Helen's going to talk a little bit more about the property-specific conditions precedent slightly later on in this talk, but it is something to bear in mind that there is quite a big exercise to go through with that, and there's a lot of paper that can be delivered. So it's something to factor into the timeline for putting these types of facilities in place. And finally, in this sort of quick dash through the sort of finance document side, I wanted to say a little bit on common security structures. So the type of security that will be taken in relation to a transaction always varies depending on the type of borrower and the transaction structure. In the real estate finance world, often we see that borrowers are special purpose vehicles. So they've been incorporated with the only purpose of sort of holding that particular property or development land. Means they have very limited history of operations, and the assets that they own are quite often limited to the property itself, any rental or sales income, and any key contracts, development documents, etc., relating to that property. So in determining its credit risk, which will also inform the lender's decision as to what security it needs to take, rather than a detailed assessment of a borrower's trading history, a lender's really going to be looking very carefully at the underlying real estate asset. It's going to be looking at the secured or projected incomes. It's going to be looking at that projected development value, who the team are, does it have confidence that development can be delivered. In terms of the security commonly taken, so often you'll see a debenture, which is sort of the most comprehensive form of security. It's an umbrella document that includes fixed and floating charges over all of the assets of the borrower, both present and future. It will cover everything from real estate to equipment to rights under contracts and income streams. Alternatively, a lender may take a more sort of restricted approach and may just take a standalone legal mortgage over a property. Now, often you see this where a borrower owns maybe other assets or has other business other than just holding a specific real estate asset. And in those situations, if the commercial agreement is that the lender is really just financing the property and therefore should have limited recourse to the other assets, that's when a standalone legal mortgage would really be appropriate. A lender may also look to take a share charge over the shares in the borrower. This is really just to maximise their options on enforcement. It may be more tax efficient for a lender to sell the shares in the borrower in an enforcement scenario rather than selling the property. So if they take the share charge, that gives them that option. And they may also take a charge over subordinated debt. Again, the reason for this is regardless of there being an intercreditor arrangement in place which would subordinate that debt, the senior lender would want the right to receive any payments under that debt, essentially to reduce the number of creditors that it's potentially dealing with in an enforcement scenario. Finally, a quick word on guarantees, which aren't security in themselves. So sometimes you see a parent company guarantee is requested where you have an SPV, which is property, which holds the property but doesn't have any trading history. Quite often you see that these are resisted on the basis that the lender's primary recourse is really to the underlying real estate asset, and they should set their lending at a position where they're comfortable that in the event of an enforcement, a sale of the asset would actually leave them with reasonable recoveries, and therefore the guarantee is not required. On smaller financings, we do see director and shareholder personal guarantees being requested. Now, ideally, these would be limited in amount, and they often are limited in amount. And we would always advise that very careful consideration is given by directors and shareholders before agreeing to these, due to the consequences for those individuals should they be called. And they are called and they are followed up by lenders. One practical point to note is that lenders will pretty much always ask for the guarantors to seek their own independent legal advice in relation to entering into these documents. This is really just to avoid any claims in the future that the guarantors were unduly influenced or pressured to enter into these guarantees, and therefore try and kind of sidestep their liability under them on the basis of those claims. So that was quite a quick canter through, but I'm just going to hand over to Helen now to talk about the property specific.
Thanks, Fee.
Sorry.
Thank you. I'm actually just going to throw you off a bit here and ask you a question, because it's been bothering me as we've gone through.
Okay.
You covered so much information, but clients will often say to me, "Oh, we get our finance documents from X bank and we sign them, we don't negotiate them, or they're non-negotiable, aren't they?" Well, looking at that huge amount of information you've skillfully packed into sort of 20 minutes of talking, is there sort of scenarios where that is relevant and where it definitely should not be relevant? You do not want to be signing these things without input, if you see what I mean, in 30 seconds, Fee.
Yeah, again, it will come down to the amount of facility. So, for example, I worked in-house at Barclays, and up to a certain level of lending, we would document the facilities on kind of bank standard form documents. And the general position under those is these are our standard terms. Essentially, it's a bit of a take it or leave it. Now, everything is negotiable. Within those documents, you would normally see kind of some commercial terms that were bespoke to the particular transaction, particular carve-outs were needed and particular permissions were needed under those documents. So I think when you're contracting on bank standard terms, yes, the starting point is normally these are non-negotiable. You need to read them and understand them. And if there's something in them that doesn't work for your business or for the property, then you do need to go back to the lender to have, it might be to agree a carve out or a particular permission in relation to that particular lending. The lender's general concern at the sort of lower level of the market is they want to keep their loans on as standard terms as possible, because banks will trade in loans as a secondary market in loans. And if they're going to do that, what they want to do is be able to take a portfolio of loans and say, these are all on the same terms, these are all on our standard terms. It reduces the due diligence that needs to be done between lenders. And so that is why they use sort of standard terms, and why you get a lot of pushback in terms of the negotiation of those. When you get up into documenting, not using standard term documents or on more kind of LMA type facilities, it's a full negotiation process that you would go through in that scenario, but that does tend to be at the higher value end of the lending spectrum.
Awesome, thanks, Fee. That's clarified it for me anyway. Right, okay, I'm talking about property-specific considerations and their impact on deal terms. Now, you will forgive me, I could cover at least a whole webinar on just this topic alone, and I've probably got about 10 minutes. So it's going to be a canter through. But as I say, ask any questions at the end, or we can arrange to speak afterwards for anyone that would be useful for. I'm going to very much focus on the kinds of things that Fiona was talking about. Are we dealing with investment facilities? Are we dealing with development facilities? And very much the headlines of how that might impact and the type of property might impact the due diligence, conditions, precedent, and documents comprised in a deal. Now, I'm a property lawyer, so I always like to look at the bricks and mortar to start with and understand the nature of the actual property involved. So I would always start by looking at whether this is a freehold or a leasehold property that we're dealing with and whether it's vacant or let. If we're dealing with a let property, then as Fiona has said, the likelihood is we're buying or lending to secure rental income. So our prime focus will be looking at those occupational leases very carefully, or at least a sample of them if we were dealing with a big estate or shopping centre type scenario. Where there are occupational leases involved, that's going to mean additional specific conditions precedent, as well, obviously, as providing and seeing all of the occupational leases and ancillary documents. There may also be additional conditions present in there around looking at rent payment history, looking at and addressing any arrears. As Fiona has mentioned, where rents are paid into, if they're going into accounts secured by the bank, amongst other things. Where we've got a vacant property, I would immediately be thinking as to how and why and when did it become vacant. Given it is vacant, then where is the income or profit going to come from in order to service any loan? On rarer occasions, you will sometimes see loans being secured against a shorter lease, more like an occupational lease, although this is a lot less common. Again, in that case, I'd be wondering, where the value is for the lender. Possibly they could be lending to fund some kind of fit out that's going to change that property from into an income generating site. So once I looked at that, the next sort of deal specific thing I would always look at is what the actual use of the property is. Now, different uses will mean very different things in terms of due diligence and issues to focus on. As Fee has talked about, where you have got a development finance situation of a development site, we are going to probably have much more detailed site-specific due diligence requirements, more extensive searches and careful investigation of the property title, as we're going to need to understand very carefully anything at all that is on or crossing or under the property, or any third-party rights over it, restrictions on access. You might have issues with inability to intensify that access. You've gone from a single track road to suddenly having loads of lorries and development vehicles going down it, for example. So we're looking at anything that could delay or impact or increase the cost of the development, thus in turn delaying the repayment for the lender or the JV partner. On the flip side, if we're buying or lending to secure income on a let site, then we've probably got, or assuming we've got, an already established operating property. So we're less likely to acquire quite such full investigation of rights and utilities and third-party rights, etc., because you've got at least some comfort that the site is already up and running well. So you may be able to take, and the bank or a JV partner may take some more commercial views in that kind of context. Sort of going down even to a more specific level, the individual site uses are also going to heavily impact the DD. For example, if you're doing a residential development, you've got to have in mind that ultimately the end user of those sites are individuals or families. These searches are very different than the searches you're going to do on a commercial site. For example, they're going to have a much higher tolerance threshold for environmental risks, a lower threshold, I suppose, for what would be acceptable versus on a commercial property. And then if you think about retail or leisure, factors such as car parking, access for the public, restriction on noise or hours of use, all of those things are going to be essential. If you looked at warehousing, for example, there's going to need to be 24-hour access, immediate access onto a highway, width of highway, etc., third-party barriers, all that kind of stuff we're going to really heavily focus on, because that could turn, a fantastic site, frankly, into a dud. As Fiona's covered a lot, the type of financing is key. With an investment facility where we're looking to secure rental income, we're going to focus heavily on anything at all in the leases that could impact that rental flow. So are there service charge caps or exclusions? Are they reasonable? Are they sensible? Are there issues with rent payment history? Are there any arrears? Are there any disputes? If we were possibly funding to somehow re-gear or relet or change the tenant mix on an existing kind of estate or shopping centre or something like that, then again, we're going to be looking very closely at the leases, but possibly slightly different points. Here, we're going to be looking at 54 Act points, break rights, abilities to surrender or preemption rights, things like that. Anything that may help or restrict us from getting tenants out or sort of moving people around, etc. Development financing, I've already indicated there, we're going to be focusing on anything at all that delay development, increase costs, or prevent it altogether, because obviously all of that is going to impact when the lender gets its money back. Finally, I guess the most obvious other scenario, we might just be funding to refinance an existing security on an existing property. In that scenario, we might be a bit more relaxed. We may do a bit less intensive DD and focus more on how the borrower is going to be repaying and anything that could impact that. Other factors I shall whip through. There'll be quite a difference if we are purchasing a new property versus if we are lending it against an existing property that's already owned by the borrower. Deal timing is going to be massively heavily influenced by the extent of the DD. Just as an indication, searches can easily take 2 to 3 weeks to come back. So if there's an urgent scenario, that's going to have to be factored into what the lender is going to agree to accept and insist on. In some situations, limited situations, it may be that DD gets pushed back until after exchange if we're purchasing, but that's only going to be where you've got sort of options to purchase or conditional contracts which are also conditional on securing that financing, such that you can take a bit of risk on the DD until you've got, say, your planning, and then you can do it at the finance stage. Fee also mentioned, does the lender have its own solicitors, or are we acting for both? That will also heavily impact, because it will impact the amount of negotiation, if any, we're allowed to do. And there's really, really tight SRA rules about the situations we can do that in. And the JV scenario, the kind of thing that Hels is going to talk about a little later on, in those situations, we see a lot of negotiation at heads of term stage, because there's a sort of fundamental mismatch sometimes between the degree of security that the owner of the property is willing to give up versus the degree of security that the lender will require. If we move on, Fee, just to conditions precedent. Now, I'm not going to go through, there's endless condition precedents you could see, and the point being that they vary depending on the type of property involved. The one I really wanted to draw out as key is the certificate of title, report on title distinction. The phrases are often used interchangeably. They're in fact very different. A certificate of title is essentially
next to you.
Someone's left their microphone on, I think. Sorry, a certificate of title is very much like a standard set of statements, and the solicitor has to disclose against any that are incorrect. A report on title is much more like a narrative report that can be written in any format. I can't emphasize enough how critical it is to understand early on in any financing situation which of these is required, because this is where, as a property lawyer, the bulk of the work will go. And if we set off down the path of doing one and in fact the opposite is required, it's a lot of wasted time and cost and effort for everyone involved. The other thing I wanted to flag is you will often see lenders are very naughty. They will present these sort of one-page supposed certificates of title that the borrower's solicitor just has to sign off. They will contain very wide-ranging statements hidden innocently in the middle somewhere, which basically are akin to saying, I've signed off on everything, there's nothing wrong with this property, and you're definitely going to be fine with your security on it. Be very wary of those one pages. They are not what they look like. I'm going to have to whip through some of these very quickly, so I'm conscious of leaving time for Hels. Other things, priority land charges, searches, basically preventing anyone else from lending or securing anything on a title. Solicitors' undertakings, which they sound innocent but can genuinely be 5 to 10 pages long, containing everything that the borrower has got to do in terms of discharging existing security registrations at the land registry, SDLT, obtaining DS1s, etc. They often take a lot of negotiation. And then the other points there, SDLT, you would expect on a purchase or a grant of a lease, discharge of existing security, which we've talked about, and then some of the other points around sort of blocked accounts, rent authority letters, and things like that a bank will require to make sure that the rental, it's got control over any rental income in an occupational scenario. I think we can move on, Fee, because all of those are. This one really, I'm not going to go through it in detail, but it was just there really as an example to sort of visually see the differences in the kind of things that we require in the development finance versus investment finance scenario. You can see just how different those two examples are. For example, in the first one, we're looking at a whole series of documents like collateral warranties from contractors, development agreements in which there'd be rights of step in for a lender if anything went wrong, and a whole raft of issues that you need to consider in those collateral warranties, obviously making sure that they're either assigned to or initially granted in favour of the lender, versus in an investment scenario where you're lending for income and you've got a lot of occupational leases, then you've got, most likely you're going to have some kind of management agreement with a duty of care in there that the lender will want to see, very similar to a collateral warranty, so that the lender has sort of rights of enforcement and a duty of care is established, but an entirely different set of documents that you would expect to see in that first scenario. We'll rattle on, Fee, to my last slide, I think. So I've covered a lot of these as I've talked, but I just wanted to set out some of the sort of most likely documents that we would see from the property side. We've talked about the conditions precedent, but in a development finance scenario, obviously we'd be looking at, there'd be a building contract, collateral warranties, development agreements, etc. Versus in the investment situation, we're going to be looking far more at management agreements, duty of care, with duty of care in them. There may be all sorts of service providers on an estate, for example, all of which the lender is going to be interested in, because it needs to make sure that that estate is running properly and its income is going to be nicely generating. Obviously, we're going to look at the occupational leases or any head leases and all the supplemental documents, rent deposits, license royalties, etc., that go alongside that. So you can see that depending on the reason for the finance and the type of property, the documents, the CPs, and everything we look at is going to be very, very different. Just as my sort of last point, in terms of documentation, if we're buying a property, then there are a whole myriad of different agreements we might see. Again, depending on where the funding is coming from and the type of property. In most basic level, you're going to have some kind of conditional sale contract or agreement for lease with hefty development obligations if it's a new build. But there's all sorts of other agreements you'll see referred to, such as forward funding agreements, forward purchase agreements, pre-let agreements, and JVs that Hels is going to move on to in just a minute. Obviously, we're used to dealing with all of those, and I could talk about all of them individually for ages. So if there's something you come across frequently, then we can pick up on that separately. And of course, finally, if we're buying a property, there's going to be some form of transfer or actually transferring the rights in the property to the purchaser, the borrower. So that was a very quick rattle through. Moving over to Hels, who's going to share some thoughts on JVs.
Thanks, Helen. I'll try and be as quick as possible through this because I'm conscious that we are coming to the end, and similar to what Helen was talking about, you could do a whole session just on joint ventures and structuring them and negotiating the joint venture agreement. So why do we use them? I've given kind of some high-level thoughts on, why they're useful. The main reasons being, they gives access to capital. You can share the capital, which basically will decrease the financial burden on each of the parties, and potentially gives you access to more deals, more lucrative deals. You can share the risk, both financial risk sharing, the market risk, operational risk, and you share that proportionately. You could leverage expertise of expertise of the other party. So, for example, one party might have certain contacts in a particular geographical location. They might have some market knowledge of a particular sector. There might be construction experience that that the other party wants to leverage, or indeed property management skills. Just to give an example, one of the deals that we work on, one of the JV partners is from a particular country. Don't worry, it's all above board. There are no anti-money laundering concerns or KYC concerns. We've done all the checks, but they have a lot of investment available, and so they work with people in the UK that that they can invest in their development and essentially get the rewards of investing in that development and leverage off the skills of the JV partner that they're working with, because that person will then go on and develop the property. That links into the second, the point below about expanding market research, using the context of each party. There might be tax and legal structuring reasons for doing so, long-term capital gains, etc. And also project-specific partnerships. You might have a specific project in mind that warrants the use of a joint venture, and you can look at ways of doing it. Another of our clients has a very niche project going on where we've set up two specific joint ventures for the investment. Our client is investing in the project and providing the funding, and will be lending the money to the company. And essentially, it's an SPV where both parties are 50% shareholders, but our client's also providing the funds, and yeah, it's quite a niche little deal that they're doing. And next slide, please. So common structures, I'll go through this quickly. So you have an equity where you contribute capital, share profits and losses. You might have a landowner one where one party contributes the land, and then the other party is the developer that handles the construction. And then we have another scenario where we refer to it as a developer JV, where you have the partners that are developers with somebody who's financing it, or a landowner for a specific project. And then I've just provided a little quote as a summary as to why they're useful. Next slide. So the JVA, that stands for the joint venture agreement, and it's essentially the contract between the two or more parties. It's often two in these types of scenarios, and they agree to collaborate on a specific project. The agreement will outline the terms and conditions of the partnership and the various responsibilities and contributions that each party is making, any profit sharing and governance, which leads me on to the next slide, where we're talking about the key provisions. So just quickly, these are just the kind of key provisions. There are other provisions, but you'll want to identify the purpose, so the project, and what exactly the role of each party is going to be in terms of successfully completing the project, and indeed what contributions each party's making. There might be contributions in terms of cash, land, or services. There might be other types of contributions like developer expertise, property management, local knowledge. And then there will also be provisions normally governing whether there is any availability for future funding, so any capital calls on the joint venture partners. Sometimes the joint ventures don't want to be committed to providing further capital. They'll want to see what, how the project is going. So that would, again, be something that's set out. In other scenarios, it might be that, somebody said, upon meeting a certain milestone, then they will contribute more. There'll be provisions governing the ownership and profit sharing, what dilution there is, profit and loss allocation, then how the joint venture is going to be run, how decisions are going to be made. It's quite similar to a shareholders agreement for those of you that are familiar with those, where you'll have certain consent rights and reserve matters. And then there'll be sharing of, liabilities and, potential provisions governing what insurance needs to be put in place, any indemnities that one party is giving to another. And then, how the joint venture parties can transfer their shares or not. There might be a complete restriction, or they might have the ability to transfer with consent, or there'll be the ability to transfer to certain affiliates or companies within their group, and that might be something that that both parties are very happy to accept. It is quite standard to be able to do that, and it's often used for tax planning purposes. And then finally, there will be provisions governing the term and termination. So how the joint venture will eventually terminate once the project's completed, or the property's sold. How will it be dissolved, and what will happen to the joint venture and its assets. And then there'll usually be some form of non-compete provisions in there as well, and of course confidentiality. And then finally, just quickly on intercreditor principles and how they interact with joint ventures. So this links into what Fiona was talking about earlier with the various levels of debt. And in a property development, you will often need bank financing, and that might be, you might not have that at the initial outset of putting in place the joint venture. It might be that you just have financing from one of the joint venture partners, and then potentially some additional loans from the owners of the joint venture, and then you would then get in place the bank financing. So there needs to be arrangements as to how those various creditors interact with each other. These can be documented in a separate intercreditor agreement, like you would see in a standard financing situation, or they can be included as a schedule to the joint venture agreement, which is actually quite common in a property development joint venture, when the joint venture partners are also creditors. And these are important because they, as I said, they reduce the or they manage the relationship between the creditors, so it would reduce the risk of conflict, and then provide stability for the project going forward. And then it will also help get that external debt that you need, because they'll want to understand what priority has been agreed between the various creditors.
Hels, I think as well, if I can just jump in, it's a useful thing to discuss at the outset, and so that the JV partners understand that the standard position is that when you bring the external debt in, they're going to expect to rank senior. And I think if those discussions have been had initially at the early stages of the JV, it's much easier than trying to get sort of you put the JV in place and then get one of the JV partners on board with the fact that they're going to be subordinated to the external debt. And I think sometimes if that's thought about at the outset, it can make putting the external finance in later a lot easier.
Yeah, that's exactly right. And actually, we've seen this recently on a couple of projects that we've been working, well, a couple of matters that we've been working on, where one of the joint venture partners has a significant amount to invest, but they are quite green in terms of doing these kind of transactions. So they don't, I guess they're a bit naive in terms, with all due respect to them, I get, they just don't have the experience in doing it. So they weren't necessarily aware that they would end up being subordinated in that way. So it's actually been really important to have those discussions up front. And in terms of how the intercreditor principles apply in the joint venture, it's very similar in terms of, what gets covered in the provisions in the joint venture agreement. It's very similar to what you would see in an intercreditor agreement, but it's normally done in a schedule, and you would cover, ranking of the claims and the various priority between the different classes of creditor. The partner debt would, as Fiona was saying, would be behind any external bank financing debts, the senior debt. There would be enforcement of standstill scenarios. So, if there's an event of default, there would be a standstill where the creditors can't do anything for a certain period. There might be cure rights, so there might be the subordinated lenders may have the ability to cure the default that's happened under the senior debt. There'll be the various security interests involved, and what access to the assets there are. Payment restrictions. So, for example, if there's a default scenario, there might be a suspension on what payments can be paid to the subordinated debt. And then there'll be the waterfall of payments, as to what happens in an enforcement scenario, how those proceeds get divvied up between the various creditors and which lender has priority. And that's into the voting and control as well, and dealing with who has the various control in what scenario. That's a very quick canter through. I know that that we are pretty much on the hour, so if there are any questions, very happy to take them. We can always do follow-up questions as needed as well. Our contact details are on one of the earlier slides.
Also, there's just one question in the chat, which I think is from Ed, which is probably relevant to you.
Yeah, I mean, we do have template heads of terms. There are standard form documents. Each law firm has their own standard form documents. We wouldn't generally just share them because no law firm would just provide you with a template heads of terms without charging for it. So apologies.
Has anyone got any other questions? Or I mean, we're happy to stay on and answer any questions. I'm conscious that we're right up against the time. Or if you,
I'd like to raise a question,
Yeah.
but if
Yeah.
nobody else is interested in the answer, I'm happy to deal with it
go for it.
outside.
Go for it, Mike. I can hear you.
In the joint venture scenario where landowner provides land and developer contractor provides build, in your experience, what's the easiest way that each party can secure their interest? I.e., we would want to raise finance to pay for the build cost, but if the land is in somebody else's ownership, have you come across situations where the landowner will accept a charge across his land in favour of a financer for the developer partner contractor? Or do you have other ways in which each party can protect their interests and their security?
And we're doing one a bit like that now, Fee, aren't we? Where we've been talking about the heads of terms for ages.
Yeah, I think I was going to say, if I just jump in on that one,
Yeah.
what we will often see in that scenario is you sort of the bottom line does end up being that the external party providing the finance would expect to sort of rank first in the structure. And so they would put their debt in and take security over the land, but then the JV partner would then take what's essentially a second charge over the land. So they would sit behind a senior lender, but are protected because in the event of a sort of an enforcement scenario, you've got the senior lender ranks first, but then their second charge ranks behind that. So they're not sitting as an unsecured creditor, albeit that they sort of sit in the middle of the structure between what would be a sort of equity provider or JV partner and the actual external bank debt. That's commonly what we would see. You can then also
So
see.
have you done it? Because every time we start off with this objective, it normally gets lost between solicitors and they can never agree the structure. And so it stays at head terms and never gets any further.
We have done it. I think what's very important is, and what can often be a sticking point is, when is the point that you bring in the external funder, and you almost need all the parties around the table at the same time to discuss that structure and to agree what the security structure and what the ranking is going to look like. But yeah, we definitely have done it where you have, as I say, external funder, senior, one of the JV partners as taking a second charge. Absolutely. But as I say, it's getting the agreement often of the external funder that they're comfortable to have that kind of second charge holder there, and then also the agreement of the second charge holder that they're happy to rank below the external funder.
Okay, thank you.
Great. Okay, I can't see any other questions in the chat, so unless anyone else wants to add anything, we'll say thank you very much for joining us and well done for listening all the way through to the end. If anyone, the slides will come round afterwards. If anyone has any further questions, then do follow up with any of us, and we can come back to you between us or directly to the relevant person. Thank you very much for your time.
Thank you.
Thanks,
Thanks,
everyone.
bye.